court and stand next to Miss Ritter. So again, here's my public service announcement. You're not gonna casualize my job. I don't come to work to see people cook, take care of their kids, lay in the bed. This is court. If you cannot attend court properly on Zoom, we are open to the public and for court. Court is open. Court is open. Court is open. Please accept to join the breakout room and then wait for the lawyers to come in to speak with you. Okay, well, it looks like Ms. West and Ms. Davis are ready, but you both must have left and come back, which it made me waste time bringing you in and trying to get you back ready. Ms. West doesn't know how to follow instructions, so I'm gonna go ahead and put her back in the waiting room. Okay. Mr. Gill, I think iPhone Jody is Gill.
What's up, people? How we doing? Just gotta get a little live in. I'm trying to get it in, but it's just so busy. Having the kiddies running around and my other job, so it's tough. But I'm trying. So let's have a little fun. I am so glad you're having this Friday with me. All the regulars are trickling in, and I see a lot of new names. I appreciate it, and the support is crazy. Don't forget to hit that live. I know you all are subscribed. I got some new stuff from Reno, Judge Washington, and Judge Stevens from yesterday. So let's start off with our people from Reno. God bless these judges from Reno. I swear they have the creme de la creme that come in. I don't know if it's a mental thing, like they have mental stuff going on and they just send them there, but it just seems that there's a lot more mental instability, to say it nicely, in Reno. Let's roll.
Conditions are a pre-trial no contact order.
Morning, Your Honor.
Good morning. Give me just a moment here. Your Honor, while you're looking at that, I did receive a response back from Department 4, and they do have 3 transports available for next week.
Oh, great. Okay. Thank you.
You're welcome.
All right. On standby will be Samantha Snyder. All right. So this is 22 CR 08798. Petty larceny, found guilty, $513 in fines, and we're here for a failure to comply warrant. Mr. McGill.
Yes.
That's correct, Your Honor, and I did receive an email from Ms. Gonzalez this morning on another case, 23 CR 08436, where he had a petty larceny charge. And correct me if I'm wrong, Ms. Gonzalez, but that was a community court case, and he had community service. Is that correct?
Thank you, Laura.
The new case? I mean, that future bench trial case?
Yeah, the petty larceny from the 23 CR 08436.
Yes, on that one, he denied the second failure to appear, and they set him for bench trial on January 5th at 1 p.m.
That's not right.
It looks like the judge entered the not guilty plea on the defendant's behalf.
What?
Yes,
So
the
did-
judge had a not guilty plea on December 19th, 2023. Your trial set for January 25th, 2024. That case.
Thank you, Amazon. Thank you, Laura.
Mr. Lefkowitz, would you like to enter a no contest plea to that and close both cases out today?
Yes, sir.
That's what happens when you refuse to come to the courtroom.
As judges get fed up with continuing, and so they go ahead and enter a not guilty plea. That's what happens.
I've been in custody 27 days
On these charges?
on the. Your Honor, I honestly thought that Judge Draculich figured all this out in November, put me in community court. They sentenced me to 8 hours of community service, and I was supposed to show up 2 weeks later. I didn't show up to court. I had a warrant. They got me on the warrant. Been here 27 days. I have
And-
somewhere to go. If need be, I'll do daily testing for the court.
He said if I have somewhere to go.
Um,
Are you interested in community court, or is he on the no-fly list?
Let me check on that one.
Well, are you even interested in community court?
yeah, yeah. I've been in custody 27 days, and I'd like to get out today. I have things I need to handle. My mother just passed away, and I have to handle her burial. There's a bunch of things I have to do for that. I mean, I'm interested in community court. Like I said, I'll do daily testing for the court. I have somewhere to live.
Odds are he's not the most responsible one in the family, so I'm sure there's other family members that are dealing with mom's burial.
Except I admit to the warrant to not showing up to community court.
All right, well, let's start there. Do you understand that by admitting, I will find you in contempt and I can sentence you up to 25 days in jail for that?
Yes, ma'am.
Do you have any questions about your constitutional rights?
No.
All right, I'll accept your admission on that case. Well, let's see if we have information on whether or not community court will allow you back.
There's no notes on the cases. There's no notes that he no longer qualifies. Both of them, he's been sentenced by community court. He was admitted into community court on November 15th, 2023 on the 23 CR 08436 case.
Okay.
And he's just pending that FTA warrant on that case as well.
All right, well, let's go ahead and dismiss that FTA warrant. So that
Thank you,
way we've
Laura.
already taken a plea on one. I'll dismiss the other one. All right, sir?
So
Now,
what is that?
Okay, since community court has not banned you, for lack of
Yeah.
a better word, we can have you transported next Wednesday directly to community court. With 2 failure to appears, I cannot release you today to go to community court on your own, because you've already proven that you don't do what you're supposed to do. So if you are interested in community court, we will set you up for transport next Wednesday.
I'm interested.
All right, let's go ahead and add him to the transport list. Mr. McGinnis, I'm sorry, did you want to add anything?
No, thank you, Your Honor.
Okay. All right, hopefully this time it'll stick. Follow whatever they tell you to do. They're there to help you. You have all the services that you need. So
Okay.
take advantage of that. All right?
I have one more question.
Uh-huh.
As of the court hearing for the 25th, the deputy told me that it's set for a trial, but this cancels that out, right?
Yes, that's right. I vacated that bench trial.
Yeah.
judge.
Yes.
Okay.
Yeah, so you don't have to worry about that. A good question, because you don't want to failure to appear.
Okay.
Well, that was a very good question. All right, well, good luck. I hope it works.
Thank you.
You're welcome. All right.
Speaking of not shutting up, let's go. I posted this clip, but this guy is an absolute classic. I gotta watch it live with you. He is fantastic. If you haven't seen it, posted it a couple days ago. I think it was my Judge Brian clip, but oh my god, this guy's
All conditions
Absolute
are
best.
pretrial no contact order and obey all laws.
Correct. We were past 9:20.
Okay, here we go.
All right, good morning. We have 24 CR 00383, trespassing and failure by a convicted person to comply with NRS 179C requirements. Looks like that trespassing was dismissed with prejudice, so we're here for a sentencing hearing. In that, in 23 CR 15770, we have a trespass not amounting to burglary during the previous 24 months with a fine of $503. That's still outstanding. And then we have 23 CR 14353, trespassing. We were found guilty. And then 23 CR 06613, another trespassing where you were found guilty. My understanding is there is a suspended sentences involved in this case imposed by Department 1. What do we wish to do this morning?
Your Honor, do we have also on record the case ending in 15770? That is a trespassing 1223 from Peppermill.
What was that number again?
23 CR.
If you watch a lot of Reno, what's going on at that pepper mill? I gotta look that up. I want to put that in one of my clips. Something weird goes on at that pepper mill. A lot of transients, a lot of arrests, just a lot of hijinks going on in that pepper mill. I don't know what the hell that is. And I think Spam asked me about Judge Boyd. The problem with the Judge Boyd videos is that everybody's posting Judge Boyd videos. So, and we have a lot of hacks. So they just record it, upload it, put it on, and those get more views because if you don't like me, you don't like my thing, you're going to go watch the regular one. So I try to avoid Boyd. I'll find like old Boyds and stuff because there's so many people doing Judge Boyd now, and they just do the upload, get as many videos as I can, ruin the niche for everybody, and I just don't like that anymore. But I love Boyd is like background music for me. Like I love listening to her during work.
15770.
Yes, that's the one where I show. Well, maybe there wasn't a plea taken in that one, but it shows $503 for fines. It doesn't show. Yeah, it shows trespass not amounting to burglary during the previous.
Oh, casino. Okay.
So we have 2 revocation hearings, 2 sentencings, and 1 arraignment is what I have.
Okay.
Yes.
Here you go.
So Mr. Waters and I have gone through his cases, as much as I possibly could, try to get him up to date. He was under belief that he was going to go to community court. However, it's the email chain that I received that he wasn't transported to community court, and Department 1 wants him revoked on the 2 cases they have. One is a 30-day sentence, the other one is a 10-day sentence. And then we need to arraign him on the Peppermill charge and sentence him on the 2 other charges.
Okay, that is correct.
Your Honor, may I say something?
No, not yet. You will have
Okay.
an opportunity at the appropriate time. Ms. Schuman.
Your Honor, well, should we take the plea on the new trespass and then I'll give a sentencing recommendation and revocation recommendation?
That sounds like a good plan. All right, so that would be 23 CR 15770. Sir, how do you plead to the trespass not amounting to burglary during the previous 24 months?
Where's this at, Your Honor? Because I got arrested last week. I was carrying a speaker across the street, but it was my speaker and stuff. I got tackled by the cops in Sparks.
Okay, don't
Right.
talk about your case.
Don't talk about your case. What are you talking about? Carrying this? Could you imagine what that looked like?
Talk to
Oh
your-
God.
Talk to
I
your
already pled guilty on this last week in Sparks Municipal. So that case
That's a
started.
different case. This is a different case.
Oh, I'm all
Mr.
blurry.
McGinnis, would you like to talk to your client?
Your Honor, I've already explained everything that I possibly could. This was at the Pepper Mill. Remember on 12/20/23, you were cited at the Pepper Mill?
These are citations? I never received any citations on the streets. I
Well,
never received, I never received any citations at the pepper mill or anything like that. I don't understand that. I don't understand what you guys are talking about with all this stuff. Like, I never received any tickets or anything like that. So
Sure.
I don't understand. Is somebody using my name or something? I don't know.
Yeah, okay.
The only thing I'm in jail for is last week, which I already pled. I already pled no contest, and then they said I was just waiting to go to community court. So that was what I was under the impression today, what I was going for. I had no idea about any citations. I never
But-
got any tickets
Okay,
from any cop.
Mr. Waters, enter a not guilty plea to the peppermill charge, and then you take that one to trial. Then we'll sentence you on the other two and go through the revocations on the other ones. That just makes sense. That's what you want to do.
But then I'd have to sit here for months waiting to go to trial, correct? Correct or incorrect?
Where's the speaker? Did they put it into evidence? Imagine the cop carrying the big JBL. He definitely didn't have a JBL. It was probably one from like Walgreens.
You have an answer for me,
JPD.
sir? Hello? Can you hear me?
You have two cases that you're going to be revoked on today. We've had that conversation. You have the two sentencings and you have the peppermill charge. Enter a not guilty plea to the peppermill charge. We'll ask the court to set a monetary bill. Then you can take that to trial, okay?
Yeah, but I'm not gonna be able to bail out on that. I want to wait for months. I'll just plead no contest to everything, whatever you guys are talking about. I have no clue what you're talking about. Let's just enter no contest to everything. Let's just figure this out. I would like to go to community court because this is ridiculous, but I mean, I don't know, man. Whatever.
Your Honor, Mr. Waters is
here for months regardless.
Mr. Waters is creating a terrible record for everybody here today. This is the conversation I had with him earlier. I went over his cases over and over and over again. This is the same reaction.
You told me you had no idea neither. We were going to figure this out right now. You didn't really give me an answer, sir.
Sir, stop talking. This is not the forum for you to go off and have this discussion with your attorney. You are creating a horrible record. I'm
Sorry.
inclined to continue this over to tomorrow and we'll deal with you then. Maybe you can calm down. You'll have a
I'm
different.
calm, man. I can deal with it now. I'll shut up.
Stop talking.
Okay.
I'm not going to take a plea just because you throw up your hands and say, I'm going to plead guilty to something I don't even know what I did. That's not constitutional and I'm not going to do it. So your case is continued till tomorrow. We'll try this again. No bail hold pending sentencing tomorrow.
Jesus Christ. Whatever. All right, thank you. So do I just go? Okay. Well, are you guys gonna let me know? Like more?
You're
by
done,
the law?
sir. Bye.
Okay.
You're gonna like let me know. All right, here we go.
Okay. Michael Banyard.
22-00428.
Okay, so I have a video coming out today with this guy, Joshua Gordonier, and they do the analytics that he tampered with the with his alcohol. It was house arrest, whatever it is. And spoiler alert, Judge Washington drops the hammer at the end. Not expected. Great video. It's longer, so I'll play it for. I'm gonna do a premiere later, but Mr. Cotton is our featured guest right now, so let's roll.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Cecilia Cotton.
Yes.
Thank you. All right, we have passed this so you could talk to him about his violations.
As to the bond violation, he's going to admit with explanation.
All right, sir, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide is the truth, the whole truth,
Hey,
and nothing but the
Monica.
truth, so help you God?
Yes, Your Honor.
Thank you. My understanding, you're going to be admitting to the violation with an explanation.
She's here.
Yes,
Yeah.
ma'am.
Admit that on November 15th, December 5th, and December 8th, you missed your alcohol testing.
Your Honor, yes, ma'am. I'm admitting to the first one. The first one I made because I didn't have the money. So the agent or the lady at the drop place, she reset it. She reset it for Thursdays because of the job that I worked and how I got paid. I was on random dropping. The other one that I missed was on December. It was December 7th. I think it was 7th.
December 5th. December 5th.
Yeah, it had to be. She had to push it back because of my check thing, and I was supposed to go the day that I came and went to court for y'all. So I'm admitting that I did miss him. And she has it noted in her thing that she had to switch it because of my payment. I have went
It is in here. It says it was scheduled for
because I didn't have the money, so they denied me going. And I did get in touch with the other. Well, this is only on this, so let me show
And
you.
how did you miss December 8th?
I didn't know because it was on random. I called her. I had called up there. I'm on random, so whenever they called, the C or the R was my days for dropping. And I had called her, and she told me just come on my next random whatchamacallit. But and then I had to call Matt, the dude, Mr. Matt, and set up my other appointments. And I have that set up for January 25th at 3.
If you were ever in court, would you say the dude Matt? Like, it's just unbelievable. I've been watching court straight for almost 3 years, and it never ceased to amaze me. Hey, the dude over there, my man over there, like.
I guess he's a drug. I guess that's the dude that I was supposed to talk to from the last one you said when I was supposed to call Miss Shannon, or I don't know her last name. I can't pronounce it. The probation lady.
All right. I accept that there has been a willing and knowing admission to the violation of probation. Are you satisfied, Ms. McDuffie?
People are satisfied. Or I think it's was he sentenced yet?
Fine.
Yeah. People are satisfied.
Defense is satisfied.
All right. As to the failure to appear for the sentencing, the report is correct. I told him if he didn't make this next sentencing, he'd be doing it from the jail. And I see he didn't do that.
What next? What's next? Whatchamacallit? I haven't missed any. I didn't miss anything else, Your Honor. I called the lady Shannon, Miss Shannon, like you told me. I set up my appointment with Matt, and my appointment is on the 25th.
Yes, but he was supposed to set up his mental health appointment by this court date. He did try to continually call Matt and Statman. They finally did call him back. He has an appointment set up for the 25th of January.
At 3:00. I did everything I was supposed to, besides the missing.
He said he did reach out to try to call probation also.
And it's multiple.
He wasn't supposed to have an appointment set up. He was supposed to have the appointment done and be ready for sentencing today.
That wasn't my fault, Your Honor. I've called Mr. Matt. Never. You have to call him, and it comes up as Google. Then you say your name, and then he picks up or he doesn't. I've left him buku messages. The first time I got a chance to get in contact with him, he set up my date for the 25th.
I do know that they are busy, and with the holidays.
Poor PD White. She's trying. She's trying.
You can
look at Judge Washington.
You can call him yourself and ask. They set it up for the 25th.
Call him right now, Judge. Call Mr. Matt, the dude, the drug. Call him.
So I mean, I don't know what else to do, Your Honor.
Ms. McDuffie?
Your Honor, I don't have any issue as long as the appointment is actually set up. Is there any sort of confirmation that Mr. Cotton?
I can give you, yes, ma'am. I can give you a number.
Mr. Cotton, let her talk, please.
Oh.
We might have to do some impulse control. Just hold on. So if there's any type of proof or, evidence that he got from them and he can submit that to the court, I certainly don't have an issue as long as the appointment is made. And as long as if he didn't start calling very, at the last minute leading up to this, then I'm fine with it. It sounds like he's been trying to get the appointment set. So if there's anything that we can review to look at the fact that appointment actually exists, I'm good.
Yeah.
I do believe he's been calling. He was very adamant when I called him the other day. As you said, with impulse control, he was very adamant and basically yelling about it, that he has called earlier over and over. And so I can try to contact them and see if there's anything they can send.
Sentencing in this matter will be February 15, 2024 at 10:00 a.m. Mr. Cotton, please get proof of
Yes, ma'am.
to your attorney.
Yes, ma'am.
Line is continued.
Thank you.
All right, so now we've seen this one before, but it's just I have to express how cringy Judge Stevens is with mental health defendants. Okay, all right, okay, like it's great. So let's do it because this girl is fantastic, and his mannerisms and his reactions are second to none. Slowly my favorite. If you don't like him, you think he's grouchy, I love him. He's the best. He's slowly, no, absolutely, actually declaring it. Judge Stevens, my favorite judge.
Yeah, that was some great Jalen Bob.
Welcome, Lindsay.
You're Jalen Bob?
Yeah.
Okay. Here in 23 CR 215, you were charged with assault on a peace officer. Uh-oh, we have a prior conviction of assault on a peace officer in 2021 in the court next door. You were convicted. Oh boy. And
Judge West closed that case.
uh-huh.
Uh-huh.
Yeah. Oh, look, who's here? It's Mr. Adams, your attorney. Right here. This is the guy right in front of you.
Oh,
There,
okay.
yeah. He sneaks up on people sometimes. He's kind of tricky. But I think, whoa, are you filing a motion for something here on this?
I need to. I have not as of.
Can you get that done so we can get her,
Yeah, I can.
get Dr. Grapon to
I'll
just
jump on
try to evaluate her and help her, because it's obvious that this court can recognize a serious condition that needs to get looked into. You understand? Here, you're looking at up to 20 years in prison if you're convicted. You understand? You don't. We don't
Well,
want
I'm gonna
that.
fight for it because
That's-
this is a new charge.
Yes.
And let me tell you, I didn't disrespect the peace. He came from me.
Okay.
So if you put hands on a lady, the lady gonna fight back. Correct?
Yes, you need to treat a lady like a lady.
Correct. So with that being said, we was at the hospital, but I didn't go to jail that
Where
day.
were you?
I didn't go to jail that day at the hospital.
Oh, it's a hospital.
Yeah, no, but I didn't go to jail that day on May 15th. I don't even remember if it was really on May 15th. And
Yeah.
they was jumping me. It wasn't even Simmons, the officer.
Well, what we're going to do.
It was another officer.
There's we're going to get a motion, and then I'm going to ask Dr. Rapon, who is a very good man, to come and talk to you and see how you're feeling and doing. Okay, he'll come and see you soon. His name is Dr. Ed Rapon. Okay, you remember that name because he needs to see you and talk to you. He's a doctor. He's a good man, and then we'll move forward and see what direction this case needs to go in.
I can do it.
Okay. All right, I'm going to reset it in 4 weeks.
I didn't go to jail today. I didn't even go to jail today. I came to jail November 13th.
I know. We need to get you.
November
We need to
13th.
get you going because that was before Thanksgiving. Hi, Howard. God bless her.
That's.
And I didn't test the next morning until I talked to Mr. Mormon.
Thank you. All right, I find that there's a knowing and willing admission to the violation. There is an explanation that he has provided, Mr. Burnett.
I'm satisfied with that, Your Honor. Thank you.
Defense
is likewise satisfied, Your Honor.
In terms of the recommendation, you've already indicated you'd like for me to follow it. Anything from you, Mr. Burnett?
No, Your Honor.
I'm just writing notes, sir.
Okay, here we go. You guys probably haven't seen this one. This is Judge Jamie Powell Horowitz. She's a little mousy. She's not like dropping hammer, but she is passive aggressive. And Miss Oak Park over here tries to turn on the tears. Ain't working.
What's your name, miss?
Javon Brooks. I'm sorry, I couldn't hear you.
Yeah. What's up, Katie? Just give me a minute. This is the raw.
This is case number 2300771. This is the people versus Jalen Brooks. All right, Mr. Bonnie, looks like we're here for an arraignment on a bench warrant.
Your Honor, I think the court's accurate. It looks like it was removed from the docket on the 6th, Your Honor, and scheduled for bond violations today. I don't believe there was actually a bench warrant issued, Your Honor. I think she was arrested for the bond violation.
All right. All right, Ms. Bonnie, give me just one moment. I'm going to recall this.
Here it comes.
Violation, go ahead.
But understanding that, I don't believe at this point in time, I've come to my client on having a bond violation hearing. Ultimately, to put the cart before the horse here, Your Honor, we're going to ask the court to reinstate the bond. It's my understanding, and I've only spoken with my client, I haven't seen any reports, but it's my understanding that my client had ultimately returned to the address to get a breathing machine that she needs for medical purposes, Judge. There was no physical assaults or any type of harassing conduct at the time. It's my understanding she's located in a separate home to live in, Your Honor, an apartment I've discussed with her. And so it's an awkward case with what the court just put on the record with there being a victim and a complainant on each side of the V.
So, Mr. Bonnie, I don't know if you can speak to this, but I think one of the biggest concerns right now, there was a small child hiding under the bed when this happened. Do you know whose child that is?
Judge, it's my client's child. He had picked her up from a babysitter and was experiencing chest pain for which he has a breathing machine. And that breathing machine was at the home. So she stopped at the home to pick up the breathing machine. I've advised her of what a civil service call is, Your Honor, and how important the bond conditions are, but she was just trying to pick up the breathing machine. That was her child.
How old is the child?
Ms. Brooks, how old is your child?
Your Honor, this is Detective Beasley speaking. If I could have a word regarding the incident.
Please go ahead.
I was there the night of this incident. I was the one who took Ms. Brooks into custody. We received 2 911 phone calls from that location with a male on the other end. First call stated that he needed the police assistance. The second call was a open line, and you could hear some rustling around. We arrived, knocked on the door. You could hear yelling and thumping going on through the door. We proceeded to, after several knocks and several attempts to get them to, or get somebody to come to the door. Nobody came to the door. The door was forced open by an Oak Park officer. We made entry. I observed Ms. Brooks standing in the front room. I asked where he was, knowing that there was a male on scene, and then I heard a male and a female yelling through the door. She looked at me and stated, "He's not here." And I said, "Where is he?" And she said, "He left." Knowing that he couldn't have left because I heard male and female yelling inside the door, through the door, we proceeded to have Miss Brooks step out in the hallway. And searching the house, we found Mr. Brooks hiding in the closet of either their shared bedroom or what used to be their shared bedroom. Ms. Brooks was, as she presents now, she was barefoot, no jacket, with no jacket on, no anything, leading me to believe that she was outside, had just come home to retrieve a breathing apparatus. She claimed that the breathing apparatus was in the basement, which she wouldn't have to access the apartment to go into the basement to retrieve the breathing apparatus, if that's what she was claiming she was there for. We have been to this address 20 plus times for family troubles, and now they have led to obviously now upping the danger of both of them now having the charge of the domestic assault. I think it's in the best nature.
Can somebody tell me where the child is now?
The child is with him, with the dad.
No, my child is with my mom.
Okay, well, when we left, the child was with the father.
All right. I do note also, looks like tickets are in default too. All right, so Mr. Bondi, I mean, I can schedule a formal hearing, but the reality is that you've got the officer here confirming that there was a violation of her bond with the no contact provision. What is it that you're requesting me to do at this point, Mr. Bondi?
Judge, at this point in time, I'm asking the court to assess a bond. I don't think a bond violation hearing is going to be appropriate. I think if it's just talking about the no contact, that's a violation. I mean, I understand that we have eyewitnesses. It'd be a waste of the court's time.
All right, let's get a pretrial date. All right, so Ms. Brooks, I'm going to see you back on February 22nd at 10:30. That'll be February 22nd at 10:30. It does seem that there was a violation of court bond no contact order that I don't know if it will result in new charges. However, it's a terrible situation for you, for Sean, for your child that has to witness these alleged events. All right, I'm going to set the bond at 10,000, 10%. I'm just going to have to do pretrial services supervision in this case to make sure that there is no contact with Ramirez Shaw or GPS tether. Also, no contact.
All right, what do we?
With Montmarch, apartment 19. No firearms, no dangerous weapons. All right, and we're going to see you back on February 22nd at 10:30.
Okay, thank you, ma'am. I'll go grab the next one. Right here this way, ma'am.
No, what did you say?
Huh?
All right, so I got a treat for everybody. Let's join.
10%, so you $1,000 to get out of jail, and then.
All right.
Let's join Judge Stevens live. Now, from what it said on his docket, he was seeing Mr. Bruce Smith. And if you look up Bruce Smith, his charges, awful. So I think we may get some live hammer dropping. So let's do it. Do it to it. Little Judge Stevens live. Yo.
Second. And Judge,
And if we're going to have to play the game of protective orders, which sounds kind of silly to me. especially in a case that I guess y'all told the judge about this case.
I suspect he did, Your Honor. I was not there.
And I understand protective orders being what they are, but they ought to be rare. Because if it's routinely used, then you get the sense that somebody thinks that they're more important than everybody else. And that's, we're like a train in this court, 550 jury trials. I want to know if there's anybody else who's ever done that. But we're speedy, we move forward, and we don't play games about, well, we're really not going to have a trial. I'm just saying that we do. We vouch for what we say, and when you have a case involving the sexual harm to a child, I'm not sure what case precedes that in importance under the law. I've done this long enough.
He's the best.
But it will be postponed 1 week, so we'll move it on that following week. And y'all just, if somebody comes up with a protective order, then we'll just have to deal with that, I guess, with the administrative judge or something. But this is a case that's 4 years old. Well,
So, and I needed a hearing in advance of our trial date because I got to make a couple of tweaks to my indictment. I wrote the edits right here. I've told Bruce about them. Bruce has no objection to the edits to the indictment, Judge. Or to the amending of, rather.
Yes, I guess they're not bringing him out. Yeah, he's a monster.
How many points is it? Two.
I see what you're doing, but I don't think it was necessary. I think it reads the way the commas are, but you can do what you want, but I don't think that there was a problem.
Well,
with this,
and to be
I've written a lot, and I can sense something when it just doesn't work right.
And
it reads
to be completely
it reads
fair,
okay to me.
I get that, Judge. To be completely fair, the real indictment that I need to fix is the other continuous.
What'd you give me?
Because I want to go ahead and fix that one because I may go on that one only.
What'd you give me this for?
Okay, when you say, so what do you want to do with this?
I'd like to go ahead and change it.
How are you going to change it?
To just move the.
You're just going to retype it?
No, I'm just handing you what I would like to change, and I can read that into the record, and then you can agree to amend the indictment.
Okay. Okay, but you don't have a draft prepared of what you wanted amended or changed to?
No, sir.
Okay. Okay, all right. Beware though. I mean, a jury can ask for an indictment. I don't generally give them the indictments. Some judges do, but if they ask for one, they get it. If that's what you want to give them.
Well, Judge, I think we've actually addressed that issue before, and they're not supposed to get the indictment. That's actually an issue that we had before.
22-41056 is now called the state of Texas versus Cedric Deshaun Joseph.
While
You
we're
are Mr.
waiting,
Joseph.
if there is anything,
Present,
let's
Mr. Lewis, you are
roll.
attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
He does, and we can't do it.
In summary, this indictment alleges that on or about September 8th, 2021 in Jefferson County, Texas, you committed the third-degree felony of evading arrest or detention with the use of a motor vehicle. You understand what you're charged with.
Yes, sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed to not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached between the parties. You would be pleading guilty, sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for 10 years, fined $500. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this indictment charging you with the third degree felony of evading arrest or detention, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily, that is on your own free will and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that?
Yes.
Voluntarily, understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection, Judge.
Without objection admitted. Among other things, this states you were mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God, as that say.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes here. So let me just look at something quickly. Defendant run a stop sign at Brockman and Avenue A while other citizens were attempting to travel north and south on Avenue A. Cedric narrowly caused a collision with multiple vehicles at the intersection. What the hell does that mean? Narrowly caused a.
He didn't cause a
was there
collision. No, there was no collision.
All right, okay. Narrowly averted.
Yes, sir.
Okay.
And then he ran
I
for a
guess
little
this is what-
while longer and
Oh.
then pulled over. Yes, sir.
All, anything else to add?
No.
If not, I'm going to find then you were pleading guilty today voluntarily, sir. You were mentally competent to do so. You understand the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in this hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third degree felony. And following this agreement, you were hereby sentenced to confinement in the institution division of the Texas Department of Criminal Justice to serve a term of 10 years. That term of confinement is suspended. You were placed on regular probation for 10 years. You must pay a fine of $500. There will be other terms and conditions of probation, which are normal and customary for this type of offense. Also, you will be required to attend and complete a defensive driving course. Actually, it's in your benefit. Not only does it help you make wiser choices, but you'll get a tax break, a break on your insurance as well. But
So thank God he wasn't drunk, but he was evading and caused a wreck. Narrowly caused a wreck.
you must understand, vehicles are 4,000-pound missiles.
There it is.
And too often we have cases in this court where people have died from collisions that have been caused by irresponsible operating of 4,000-pound missiles. When you're driving a vehicle, other people are relying on you for their safety. And when you don't act that way, it's a very selfish and dangerous way to act. Anything else?
No,
That is all. Thank you.
Thank you, Judge.
All right, people. It was great. I'm going to try to get as many lives as I can. You are the best. Let's get some court watching. I am going to have a premiere in a couple hours of that Judge Washington. It is a doozy, I promise. Thank you all. Make sure to kiss your loved ones. Enjoy the playoffs this weekend. Stay healthy and happy. I'm time. You have been served. That is all.